Okay, the next case we have on the docket is NIEVES versus UPR Group, Inc. And whenever you're ready, counsel, you can begin.
Thank you, Your Honor.
Good morning.
May it please the court, I'd like to reserve 7 minutes for rebuttal.
Okay.
My name's Margaret Kozan, and I represent appellant Jenny Nieves. This is an appeal of a summary judgment entered by the trial court in favor of the defendant below and the appellee here, UPR Group, doing business as Bravo Supermarket in a premises liability slip and fall case. This appeal hinges on a very discrete issue, albeit a tad nuanced. The issue is when there's evidence that the defendant's employee spilled the liquid that caused a claimant to slip and fall in a business establishment, is the actual knowledge requirement of the transitory foreign substance statute in Florida met? And we submit that it is, based on longstanding Florida case law. This principle has been recognized by this court in the Barber decision. It says there, actual knowledge of a dangerous condition exists when the establishment's employees or one of its agents knows of or creates the dangerous condition. It's also been recognized by Justice Wells in his concurring opinion in the Owens versus Public Supermarkets case. It's been recognized by federal courts applying the statute since its implementation, and it's been recognized by the Florida Supreme Court in decisions dating back to 1953, including Carl's Market versus Meyer. And indeed,
the problem here, I mean, I don't think anybody contests that Ms. Nieves fell and that she was injured. The problem is, what evidence really is there? I mean, in the Barber case, the woman apparently determined she fell on a toilet paper roll and some kind of mechanism in the restaurant, and the management testified, maybe even a couple of employees testified, you have to have a key to unlock the toilet paper thing. So the only way the toilet paper roll and mechanism got on the floor was somebody from the restaurant must have not locked it or unlocked it or whatever. So you could kind of there build reasonable inferences. Here, the former employee who testified, he was doing a little detective work at first, trying to figure it out, but when he was really pressed on it, he admitted he didn't see the water come out. He doesn't know for sure. And when asked, I can't remember if he was asked specifically or he just volunteered, he goes, I don't have a basis for saying that the water came out of Miss Ada's cart. And he asked Miss Ada, and she said no. Now, whether that means no, she wasn't pushing it, no, it didn't come out. If anybody could have confirmed it, perhaps maybe it was Miss Ada, and she didn't. And, you know, I know y'all are going on actual knowledge, not a regular pattern here, but I mean, he says this is done every day and never ever had it happen before, and he doesn't know why it would happen this day. I mean, it just seems like an awful tough case with some things that might have developed, but there's nothing here to go to a jury on. So I mean,
well, I disagree, Your Honor. I think that we're entering the realm of weighing evidence and judging the credibility of witnesses, which isn't appropriate on summary judgment. There is testimony by both Ms. Nieves and by Mr. Tavera, who was the assistant manager who cleaned up the spills, that there was a trail of water spills that went from the deli area to the storage area.
Which Ms. Nieves said, I mean, in her testimony, in her deposition, she thought it was a produce guy putting plantains out, and she points out that the water went to the storage area where the bathrooms are.
Well, that was her initial speculation. She did see a produce guy, but that was before she had the benefit of the the surveillance video that was produced by Bravo in evidence, and the timestamp on the video, and this was brought out in Mr. Tavera's deposition testimony, shows that she transported that pot full of water, covered only with aluminum foil, from the deli area to the storage area just a little over a minute or less than 2 minutes before Ms. Nieves slipped and fell. And it's undisputed that there was a trail of water on the floor. I mean, it was cleaned up by a Bravo employee. It's undisputed that she did indeed transport that pot just before.
I don't think anybody disputes that it could have come from the cart. And you know, maybe sitting around talking about it, kind of seems like it's likely it came from the cart. But there was no proof by anybody that it came from the cart. There was no witness who could say it came from the cart, I saw it come from the cart. I mean, whoever looked at the video, nobody said, I see, look, it's coming out. I mean, it's an unfortunate case in terms of nobody doubts there was water on the floor, but there's several cases cited in both briefs that says a wet floor and a slip and fall doesn't get you there. And that's kind of, I mean, tell me why that's not where we are here.
Well, I think that the court in the Taruno case, which was out of the Southern District of Florida, is a very similar case to this. And in that case, an employee had carted a box full of frozen, or box full of chickens right before in the area right before the claimant slipped and fell. And the claimant had also taken a chicken out of the cooler and put it in her buggy. And the defendants argued there's no evidence of actual knowledge here because nobody testified that they saw the box of chickens that the employee was unloaded actually leaking. And it's just as likely that it came from the claimant hauling her chicken from the cooler into the cart. But the court, correctly, I think, denied summary judgment and said you don't have to see somebody actually spilling the water because you have two types of actual knowledge. And granted, it's somewhat of a misnomer, but the case law recognizes that when the defendant's employee creates the condition, and if there's circumstantial evidence from which you can draw the inference that the defendant's employee created the condition, then summary judgment is improper. And just because you could also draw an inference that the plaintiff herself created the condition, that isn't sufficient to defeat summary judgment. So like I said, there are two kinds of actual knowledge. There's one of actually observing a condition on the floor, and the other is creating the condition. And the case law recognizes that when the defendant's employee creates the condition, the actual knowledge requirement is satisfied.
Counsel, you cite to the Toronto decision. That's a decision from the Federal District Court relying on the federal rules of procedure.
That's correct.
Is there a difference between the federal rules and Florida rules when it comes to this issue?
Well, I think we have a more favorable, at least for now, summary judgment standard in the state court. The court does do a little bit of discussion about inference stacking and says we don't have the same limitation on inference stacking. But in this case, I don't believe that any inferences need to be stacked. You can piece together evidence, but that's evidence, and circumstantial evidence is just as persuasive as direct evidence, and it still counts as evidence. And I think there's sufficient evidence here for the jury to decide. It becomes a jury question. So, I'll reserve my remaining time for rebuttal.
Good morning.
Good morning.
Maureen Piercy on behalf of the appellee UPR Group, doing business as Bravo Supermarket. I'd like to go back to the Taruno case very quickly because, as was just pointed out, they have a completely different rule of evidence. And they have no prohibition against stacking inferences. So that you can't apply that when you're looking at Florida law. I think that's very clear. And if you go back, we have Delgado, Lago, McCarthy, and there may be a few others that all say water alone isn't enough. So what do we have? No one saw the spill. Another thing that I'd like to point out is the pot of water we know, had vegetables in it, water, grasses and herbs. But what we saw on the floor was clear water, and that's undisputed. So we have no explanation of what happened. The water spilled out and the herbs and grasses, I guess, evaporated somehow. It doesn't make sense. So the initial inference, and this is pretty clear in the case law going back to Trussell, the initial inference has to be to the exclusion of all others. And as was pointed out by the panel, you can't do that here because we don't have any direct evidence. So we have a line of water. We know from the depositions and the witnesses who looked at the video during the depositions, there were several people coming through this area. I think there were at least 4 or 5 different people that had gone by. The video is showing a small area, and they talk about it. You can't see what's happening over here. You can't see what's happening over there. So we know a bunch of people went through this area, and it's in the aisle of the supermarket. It's not in, as in Barber. It was something that the defendant had exclusive control over. The manager of the restaurant in Barber said, no one could figure out how to unlock that mechanism unless they knew, even if they had a key to it. And in the other cases that were cited talking about the same issue, we have Everett, where they saw someone place a board there. So all of these cases, we have a situation where there's either some sort of exclusive control over the condition itself or the area, and that's not the case here. Or we have a witness. So we have cases, Carl's Market, I believe, was the one where we had several people fell right before. We had cases where Thomas, which is an older case, where it was only waitstaff who had access to this area. It was an area where they pour the beverages in a restaurant, Cracker Barrel restaurant. They were the only people who had access there. They're the only people moving around carrying beverages, and that's where there's this big spill. So we don't have that situation here, and I think the only way that plaintiff gets past summary judgment when you look at the current statute and the case law is she has to stack inferences, and because that initial inference is not to the exclusion of all others, you can't go to that second inference.
I mean, the common sense tells you kind of what Mr. Tavera was looking at. You see the cart, he knows what's in the cart, you see a trail of water where the cart either came from or went. Kind of makes sense that that's what it is, and I think appellant's saying, well, if it's common sense that that's where it came from, why can't a jury then use its common sense to decide whether that's where the water came from or not?
Because if you look at the language of the statute itself, it's saying that the plaintiff has to show actual or constructive knowledge. I understand this is summary judgment, and so our initial burden was to say there's no evidence of actual or constructive knowledge. And their attorney even recognized at the trial level, no one knows, and I believe counsel acknowledged here today, no one saw that water come out, so we don't have actual. So we're looking at constructive. And that's when you look at the case law that says what shows constructive knowledge. Maybe it makes sense, but maybe a customer went in the bathroom, washed their hands, and trailed water somewhere. We don't know. Maybe a customer had a beverage in their hand that was dripping. Maybe it was hot outside. I don't know. But that's why we have this whole line of cases, and that's why the law is very clear. When you have a situation like that, that's exactly when we've seen summary judgments granted. And we have, since the statutes come out, I think we have at least 10 different cases where they've granted summary judgment. Another case that came out of this court was Hussein, and that's where there were eggs on the floor. And there's one egg that the woman tripped and fell on, but then there were other eggs also on the floor. It almost looked like maybe somebody dropped a bunch of eggs or maybe dropped part of a carton, something like that. There's track marks in it. That still was insufficient because no one knew how the eggs got there. The woman herself may have tracked them. Here, all we have is a clear liquid and nothing more. And that's the whole problem with getting onto their second step, which is somebody who is pushing a pot, and as was pointed out, that pot comes through there every single day, and it's never happened before. So they want to infer effectively that you pushing that pot through there is creating some sort of danger because it has water in it and you go from one area to the store to the other every day, but we have no evidence to prove it. And I don't see how we get beyond that. If there's anything else the court has for me, then I would ask that you affirm. Thank you.
saying you have about 12 minutes.
First of all, I disagree with the premise that just because no one actually saw the water spill, that you cannot have actual notice to satisfy the statutory requirement, because of the longstanding case law that says when a defendant's employee creates the condition, the actual knowledge requirement is met. So you don't get to the constructive notice factors. How long was it there? Were there track marks through there? And that's what the trial court, I believe, mistakenly focused on here. And we do have sufficient evidence because we have the surveillance video that was played to the assistant manager during his deposition, and he testified that every day she brings this cart through, it's full of water, but it's covered only with aluminum foil. Yes, it has vegetables, yes, it has herbs, but those are uncooked. So it's reasonable to presume that when the vibrations of the cart pull it through, the water would slosh out, not necessarily everything else. Nobody's contending that the entire pot itself spilled, just that there were sufficient vibrations from the cart to spill the trail. And it's consistent with the trail of water that went from the deli area to the storage area, and that's sufficient evidence to present a jury question on whether Bravo Supermarket was negligent.
Does the video depict any type of water or liquid spilling?
My understanding from his testimony, it's difficult to discern it, to see it actually spilling, because I think the video was grainy. The video itself did not make it into the record, but it was shown to the assistant manager who cleaned up the spills, and it also refreshed his recollection because he did ask the employee who carted the pot through that area. She denied having done it, but he remembered after seeing the video that he had questioned her about it at the time, and there's no evidence of any other source of the water in the area. And so I think this case is distinguishable from the circumstantial evidence cases where there was no evidence at all as to any source of the water, that it may have been from the defendant's employee's creation. And so this becomes an actual notice case.
But even as to the video, Mr. Tavera's testimony, on 208 of the record, and then since it's 4 pages to a page 78, Tavera is asked, so if Ada had dropped the water as you speculated, shouldn't you have been able to see it on the video? And he said, that's correct. But he didn't see it. And, you know, he came close, he was helpful, and like I said, very common sense. And I think common sense tells you that it may have come from there. But when he was asked, you know, did you ever see it? No. Do you have any basis for knowing that that's where it came from? No. So, I mean, I think he was going through common sense like everybody else might go through common sense, but if you couldn't see it on the video, you really can't tie it other than it could have come from the cart.
But there's no other source of water in the area, and so I think that still is sufficient to send it to a jury and let the jury decide, and the defendant can explain, and he can equivocate to the jury, but I think it becomes a jury question on Bravo's negligence. So like I said, I think this is very close to the Taruno case, and in that case there was evidence of another potential source, and the court said just because you can draw more than one reasonable inference from the evidence that is there doesn't mean it's inference stacking. It means it's a jury question, and again he differentiated actual knowledge of actually seeing somebody spill versus evidence that a defendant employee may have created it. And if you have evidence from which you can infer that fact, then it becomes a jury question as to the defendant's negligence. Thank you.
Thank you.
Thank you.
And we're in recess. Thank you.